Welcome to James Madison's Montpelier. I'm Ryan Nobles from NBC 12 in Richmond, and we're continuing our conversation on the Bill of Rights, joined by Police Chief Tim Longo from Charlottesville, who's also an attorney, Hank Chambers, who's a law professor at the University of Richmond, and Peter Irons, who's a widely published author and the political science professor emeritus at UC San Diego. We're talking now about the Fourth Amendment and how it's practically applied today. And Chief, have there been examples of where the court has perhaps gone too far in throwing out evidence because it wasn't properly acquired? And you've talked about this before, but in many cases allowing guilty defendants to go free?
No, as we've said in previous discussions, I think the court's been very careful in how they use the exclusionary rule. It's a great case just a few years ago, Hudson versus Michigan, where the court spends a lot of time talking about why they came up with an exclusionary rule to prevent police misconduct, for example. And in the latter part of their opinion, they say, but look, things are a lot different in this profession now. Police officers are better trained, they're better supervised, there are internal disciplinary processes that departments undertake when officers run afoul of the law. And oh, by the way, there are civil remedies. There are ways in which to hold police officers, police departments, and municipalities responsible for misconduct.
And do you find it's your responsibility then to make sure that your officers understand the way this works before they go into an investigation?
It's absolutely my responsibility. Not only is it my responsibility, it's the responsibility of our profession to make sure, as the courts pointed out, that officers are properly trained in what the Constitution means, and in this case, the Fourth Amendment, and how it applies to their work.
With respect to the Fourth Amendment, what we tend to require is that police have a legitimate reason for not having a warrant. If they have a warrant, usually all bets are off. If you have a warrant and you found stuff pursuant to a warrant, it's coming in. It's only when you have a situation where you don't have a warrant and you have an unreasonable search that usually that becomes an issue. And one of the things the Supreme Court has done in the last 50, 60 years, what have you, is describe situations when police officers can reasonably engage in searches in situations where they don't have warrants. So that's sort of another piece of the puzzle.
And Peter, what's one of the more misunderstood aspects of the Fourth Amendment?
Well, I think the most misunderstood or most difficult to apply is this concept of reasonableness, because judges can differ among themselves. What's reasonable? You see this a lot in appellate decisions where one set of judges will say this search was reasonable and another will say it's not reasonable. But there are a lot of situations, sort of this gray area, where, for example, there are exceptions like the plain view doctrine. If you one of your officers stops somebody in an automobile on for speeding or something like that, and sitting on the seat next to them is a bag with a little what looks like contraband in it. They're entitled to take that even without a warrant because it's in plain view.
There have been instances where the Supreme Court have relaxed the probable cause standard, which is articulated in the Fourth Amendment, and said that there are circumstances when the public's in danger or where the officer or others around him may be in danger, where he or she can act with what the court called reasonable articulable suspicion to believe a person is engaged in criminal activity. And take it one step further, if they again have reasonable articulable suspicion to believe that person might be armed, they can conduct a limited pat-down in an effort to confirm or dispel that suspicion. That's one piece of it. The second is there are circumstances where there are exigent circumstances, that there's an urgent, immediate, and compelling need to act. And oftentimes the court will allow for exigent circumstances to not accept the Fourth Amendment but satisfy it as an objectively reasonable search and or seizure.
Has it changed in this era of us being concerned about a war on terrorism? Have we maybe relaxed some of the standards with the Fourth Amendment as a result of our concern that there may be some sort of mass casualty event?
It's sort of the classic thing. If we don't get this information, there might be a more terrible result. And this is where, there are international laws that deal with this, the Convention Against Torture, for example. But in recent years, the federal government has taken the position that what they call enhanced interrogation techniques are necessary to get information from people who might be part of a broader and more dangerous conspiracy.
Gentlemen, thank you.
Thank you.